Dear viewers, welcome to another session on the course of property law. I, Dr. Vijeta Singh from SS Mania Law College, Jalgaon, Maharashtra. Today we are going to discuss restriction for beneficial enjoyment of one's own land. Let us have the introduction of a topic. Transfer of property from one person to another includes various rights such as to own, to enjoy, to alienate, etc. When transferor imposes any condition which restrains transferee from the alienation of the property, it is called rule against inalienability, and it is void as per section 10 of Transfer of Property Act. Alienation, further transfers of property, condition, precedent, condition subsequent. Condition precedent means it puts prior to the transferor and the actual transfer depends on the compliance of condition. For example, A will transfer his property to B only if he marries to C. Condition subsequent, put and to be fulfilled after the transfer. These conditions affect the rights of transferee after transfer. For example, A transferred his property to B with a condition that if he marries to C and the property will revert back to A. Section 10, 11, 12 and 17 talks about illegal restrictions on transfer of property. Such restrictions are deemed to be absolute restraint which deprives the owner of property from its enjoyment. Alienation is the process of giving or selling the title of property to another person. When property is considered alienable, means the property is able to be sold or transferred to another party without restriction. This is based on the general rule of jurisprudence of alienatio re pare further accrescendi, which means alienation is favored by law rather than accumulation. Condition absolutely restraining right of alienation would condition not transfer. For example, A transferred his property to B with condition that B shall never sell it. The condition is not valid as per section 10, condition restraining alienation. Section 10 says, if property is transferred subject to any condition or limitation which absolutely restrains the transferee from alienation of parting away with or disposing of his interest in the property, then such condition is void. Section 10 again says, condition restraining alienation when property is transferred subject to condition of limitation, absolutely restraining the transferee or any person claiming under him from parting with or disposing of his interest in the property. The condition of limitation is a void except in the case of lease, where this condition is for the benefit of the lessor or those claiming under him, provided that property may be transferred to or for the benefit of woman not being a Hindu, Mohammedan or Buddhist, so that she shall not have transfer or change the same for her beneficial interest therein. This is based on the general rule of jurisprudence. Alien ratio re pare fortiori accrescendi. That is to say that alienation is favored by law rather than accumulation. This is the general economic principle that there should be a free circulation and disposition of property. An absolute restart is repugnant to the nature of the state and is an exception to the very essence of the grant. This section lays down that where a property is transferred subject to a condition absolutely restraining the transferee from parting with this interest in the property, the condition is void. Thus, if A transfers his property to B with the condition that B shall never sell it or shall sell it only to a particular person, the condition is void and B any sell or not as he pleases. Here the section states that only the condition restraining alienation is void and not the transfer itself. Now, we will see the exceptions to section 10. Whenever any property is transferred which absolutely restrains transferee from disposing of his interest, when such restraint would be considered as void. However, there are certain exceptions to the rule restraining on alienation. Exceptions are in the favor of lesser and other in the favor of a married woman. As previously we have seen, lease. A condition in the lease deed, lesser can impose a condition that leasee shall not be sublease it. A condition imposed in the lease deed that leasee will have to surrender the property in the event that lessor needs to sell the property will be considered to be valid condition. Thus, any condition restraining leasee from alienating leasehold property is not invalid. Married women, section 10 provides second exception in relation to married women who is non-Hindu, Mohammedan or Buddhist. It provides that property may be transferred to or for the benefit of a woman not being Hindu or Mohammedan or Buddhist. In such cases, transferor can impose a condition which restricts the right to alienate the property further, and such condition would not be considered as a void. Essentials of section 10: transfer of property, condition, absolute restraint for making alienation, effects. Such transfer from transfer to transferee is valid, but the condition imposed on transferee is void. Kinds of restraint. Absolute restraint. It is totally takes away the right to disposal. Restriction in respect of time, consideration, person, purpose is void. Absolute condition restraining alienation. Section 10 of the Transfer of Property Act declares a condition void if it completely restricts alienation. An absolute restraint on alienation occurs when it entirely removes or limits the right to dispose of property. This section protects the transferee of immovable property from absolute restraint on dealing with the property as its owner. This provision applies when property is transferred with a condition that absolutely restricts the transferee from parting with their interest in the property. To render such a condition invalid, the restraint must be absolute. The restraint can take various forms such as limiting the power of alienation in terms of time, specifying a particular person or adopting any other form. The determination of whether the restraint is absolute or partial depends on the content of the deed. Friends, we will see some illustration for more clarification. A sells his house to B with condition that B cannot transfer the house to anyone except C. This condition is void because C may never choose to purchase the property. If A is being a husband, settles his properties on his wives with the condition that they cannot transfer the property without his consent, this condition is void as it completely takes away the wife's power to alienate the property. It happens in the exceptional cases of Muslim law. In the case of a will where an absolute right is vested in an adopted son concerning the properties bequeathed to him, no further restrictions can be imposed under section 10 and 11. This includes restraints on alienation or creating restrictions conflicting with the interest created in the property. The legatee receives the property as if the will contained no such condition in accordance with section 138 of the Succession Act. Rosser versus Rosser, 1884, one of the oldest case. A died leaving behind his son and wife and left his entire property to his son with the condition that if he wants to sell the property, he must have to give preference to the testator at the price of $3,000, which is 1/3 of the $15,000 price at the time of death of testator. Partial restrainment. Condition imposing a partial restraint is valid. Section 10 of the Act has only provided for absolute restraint and it's silent on partial restraint. When any such transfer which does not take away the rights of alienation, it is considered to be partial restraint. Partial restraint as regard to time, place or person is valid and enforceable. For example, A transfer property to B with a condition that he should further not alienate in the favor of D, who is trade competitor A. It contains partial restraint and is considered to be a valid. A total restraint on the right of alienation is void, but partial would be considered as a valid and binding. This rule is based on sound policy of free circulation. A condition which is imposed in the bylaws that the property cannot sold to non-Parsis will operate as a valid condition. Muhammad Becca versus Abbas Bondi Bibi, 1932. In this case, a condition cannot be sold outside the family member is partial restraint and was declared valid. Let us say exceptions. Lease. Any condition restraining lease from alienating leasehold property is valid. In case of Raghuram Rao versus Eric P. Mathias, 2002, if perpetual leases, any condition restraining the lease from alienating the leasehold property is valid. Transfer to women for her benefit, not Hindu or Muslim or Buddhist. Property may be transferred with the condition restraining the alienation during her marriage is valid. Section 11. Condition restraining enjoyment of property. According to section 11, the condition in restraint of enjoyment of property is void. It means if the transferor imposes any condition on the transferee restraining him from enjoyment of property, such restraint by the transferor is void and the transferee is not bound by such condition. Let us see the ingredients of section 11. Absolute interest is created in favor of transferee. Condition restraining enjoyment. Exception to section 11, transferor may impose condition restraining the enjoyment of land. if such restrictions are for the benefit of his land. For example, A has properties X and Y. A sells his Y property to B and puts a condition that B should not construct more than one floor. So, for A's property should get good air and light. Section 11 contains one exception which is for the benefit of the transferor, and it states that the restriction repugnant to interest may be created. Wherever any property is transferred absolute, the transferor can still impose a condition or a direction that restrains the mode of enjoyment of the only piece of property of a transferor for the beneficial enjoyment of some other property. Such direction will be considered as a valid direction. The transferor must give a direction, and such direction must be made in respect of one piece of immovable property for the purpose of securing beneficial enjoyment of another piece of such property, that is transferred to the transferee. A condition imposed by the transferor may be positive or negative. When any property which is transferred and the condition imposed by the transferor is positive, then the transferee is bound to fulfill such conditions even if it restrains his enjoyment of the property. Where any such condition imposed is negative, the transferee is not bound to fulfill such a condition. In the case of Indu Kakkar versus Haryana Industrial Development Corporation, an agreement between industrial corporations and industrial units with the condition that industrial units shall be established within the specified time, failing which their interest shall cease. The Supreme Court held that condition to be valid, causing no restraint on the mode of enjoyment of property, and therefore, the agreement was held to be valid. Positive and negative conditions. First, we will see the positive conditions. Positive conditions are those conditions which are imposed on the transferor, where the transferor imposes a condition on the transferee to do some act. For example, A transfers land to B on the condition that he shall maintain and keep filling up the well on that plot of the land. This condition is called positive condition. Then what is negative condition? Negative conditions are those conditions which are imposed on the transfer. When the transferor imposes a condition on the transferee to not to do some act. For example, A transfers land to B on the condition that he shall leave upon a 4 feet wide space on the land and would not build anything on it. This is called a negative conditions. Section 12. Conditions terminate the interest in case of insolvency or attempted transfer, where the property is transferred subject to limitation or condition that the transferred interest shall cease if the person becomes insolvent, and such a type of condition shall be void. After a person becomes insolvent and tries to dispose of the property or such interest even at that time, such a type of condition which restrains him from disposing of his property absolutely shall be declared void. Let us have a glance over the difference between section 10 and section 11. What exactly section 10 specifies? That in the transfer, which condition that absolutely restrains the alienation of the property by the transferee, the condition will be deemed to be void. Section 11 specifies that in a transfer where absolute right in the property have also been alienated to the transferee, and where a condition is imposed that the transferee cannot, in a spit of having the absolute right in the property, do an act for his enjoyment of the property, such condition will be deemed to be void. Thus, the difference in these sections are that in section 10, the condition is deemed void due to absolute restrainment, and in section 11, the condition is deemed to due to the transfer being absolute nature. Let us see the exception to section 12. Lease. Only partial interest is transferred to lessor can impose such conditions. Section 17, direction for accumulation. When the transfer is done with the condition that whatever income arising from the property shall be accumulated and given to someone, it is called the doctrine of accumulation. But the maximum permissible period is 18 years. Secondly, lifetime or transferor, whichever is a longer, any direction for accumulation of a higher than this period will be void. Exceptions to this rule: time period will not be applicable. Accumulation for the payment of debt of any other person taking in interest under the transfer. Accumulation for providing maintenance to children, grandchildren, etc., or transferor or any other person taking any interest under the transfer. Accumulation for the preservation or maintenance of the property transferred. Section 18, benefits of the public. For example, A transfers its house to B in 1960 with direction for accumulation of its rents up to 1990, and meanwhile A dies in the 1917. Here the transferor lives only 10 years, which is less than 18 years. So, the direction for accumulation is valid only up to 1978, that is up to 18 years from the date of transfer, because it is a longer period as per section. Section 17 is exception to the rule of section 11, rule against perpetuity. Section 13, transfer for the benefit of an unborn person. A property cannot be transferred directly to an unborn person because of the principle that a property cannot be ownerless. The interest of the unborn person must be reserved by the prior interest in some person until the unborn comes into the existence. The unborn person must be in existence when the prior interests come to an end. The interest created in favor of the unborn person must be absolute interest. Near life interest cannot be transferred to the unborn. In this regard, there is one famous case, Tagore versus Tagore, 1872. The Privy Council observed that a fetus or infant in the womb is a person in existence for the purpose of making a gift to an unborn person. What is meant by rule against perpetuity? It is the rule which is against a transfer and makes property alienable for indefinite period or forever with the property's transfer in such a way that it becomes non-transferable in future for an indefinite period. The property is tied up forever. This disposition is called transfer in perpetuity. Perpetuity may be created by two ways. First, by taking away the right of alienation. Second, by creating the future remote interest. Let us see the exception to rule against perpetuity. Transfer for the benefit of public. Section 18 of a Transfer of Property Act is one of the exception. It states that where a property is transferred for the benefit of the public in advancement of a religion, knowledge, commerce, health, safety or any other object which is beneficial to the public at large, a perpetual transfer is not void. The purpose of the exemption is to enable the formation of a trust. Generally, a transfer in the public interest is made via a trust. In the trust, the property is tied up in a trust for an indefinite period to achieve the object for which the trust is created. If section 14 will be made applicable in such cases, it would be defeat the purpose of such trust. Personal agreements not creating any interest in the property are exempted from the rule against perpetuity. In the case of Rambaran versus Ram Mohit, the Honorable Supreme Court held that mere contract of sale of immovable property does not create any interest in the immovable property, and therefore, the rule against perpetuity is not applicable in such cases. Redemption. The section does not apply where there is a covenant of a redemption of the mortgage. Section 14, Rule against perpetuity. No transfer of property shall create such an interest which is postponed after the lifetime of purpose, in whom life interest was created, an ultimate minority period of the ultimate beneficiary, maximum possible remoteness of a vesting life of the preceding interest period of gestation of a ultimate beneficiary of minority of the ultimate beneficiary. For example, X transfer his property to Y for lifetime and then Y's unborn son when he attains the age of 27. The transfer is void because it exceeds the time of perpetuity. Essential of section 13, Saundara Raja versus Nataraja. It was held that at the date of the transferor absent knows whether the guardian would be appointed by the court or not. So, for the purpose of section 14, then the minority period would be 18 years. Section 18, Exceptions to the rule against perpetuity. First, benefit of the public welfare. Second, for the advancement of religious knowledge, health, commerce, etc. Third, vested interest. Fourth, no application to personal contracts. Fifth, contract for the perpetual renewal of a leases. Sixth, when only change is created. And seventh, a contract of a redemption in the mortgage. Eighth, a contract for preemption in respect of land when the property is transferred for the benefit of class of unborn persons, and if the transfer fails with regard to some of them because of the rule of section 13 and 14, then whole transfer will not be valid. The transfer in regard to other transferee who are capable to take the property will be valid. For example, A transfers his property to B for life and then X, Y, Z who are all unborn at the date of transfer, with the condition that X and Y shall get the property where they attain the majority, but Z shall get when he attains the age of 25 years. Here, the transfer in regard to Z fails under section 14, but in regard to X and Y, it is valid and shall take effect. Section 16. In transfer of property, if prior interest fails because of the rules of section 13 and 14. The subsequent interest also fails. The validity of later interest is dependent upon the prior. Friends, after above discussion, we came to conclusion property is understood as a bundle of rights. It includes both rights to enjoy the property and to alienate the same. Thus, the state recognizes that it should protect all such rights of the transferee. The transfer can be inter vivos or under a will. The inter vivos transfer is governed by the Transfer of Property Act, whereas the transfer by a will is governed by the Indian Succession Act or by any Personal Succession Act. Both these statutes recognize the rule against perpetuity. The rule against perpetuity is imposed on the ground of equity and public policy. It enables the transferee to enjoy the property as well as ensure that he is able to alienate the same if needed. However, the right to alienate also has certain exceptions which are required to protect the right of holder of property, transferor and transferee. Thank you.